have not seen the judiciary anti-sexual harassment policy tested in our courts. I've not seen it tested in our courts, but we have certainly seen other organizations' policies being tested in our courts, and there's rich jurisprudence on that.
Okay, let me leave it at that. Thank you very much.
Oh, you've already done. Okay, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, Judge.
Good afternoon, Commissioner.
I'm the person who is known for offering water. So if you need water, you can take the water.
I had drank some outside.
Great.
Thank you.
Okay. We've gone through your sample writings. You submitted 5. One is on constructive decisions on constructive dismissal, industry action within the right to industrial action within the medical sector, freedom of religion, and unlawful termination. So your writings show strong command of employment and constitutional law across public and private spheres. You demonstrate the ability to identify and frame issues precisely. You're able to apply precedents well and balance competing constitutional and statutory interest without absolutism. Your tone is measured, coherent, and restrained. And we see you have contributed into the development of jurisprudence around the area of employment and labor. So we thank you for that.
Thank you.
So among the sample writings you submitted was on religious freedom with regards to employees of the SDA Church. And you did hold that there was a violation when their employer failed to allow them to worship on Saturdays.
Yes.
If the scenario was different, where the employees were members of the Kenya Defence Forces, how would you balance the rights of officers from the Kenya Defence Forces with that of national security that requires KDF officers to practice, offer their services, including on days that they're expected to pray or they're not expected to work? How would you balance the two rights?
Thank you. Actually, even in that decision that you have mentioned, I made it clear that freedom of worship is not absolute. So there are days that even for SDA adherents, they'll be required to work on Saturday. But what I said is that a policy that is rigid, that says our hours of work are Monday to Saturday, is unreasonable. So in the same vein, if I were to do that case for defense officers, I would say that if they are required to work every Saturday throughout the year, they never have time to pray, then that is unreasonable. But I would also say that I would expect flexibility on both sides, so that the officers are flexible enough to negotiate with their colleagues to hold their fort. But the bottom line is that you can't say an employee will never worship for the rest of their lives. That would be my view.
Okay, so within the context of national security?
Within the context of national security, of course,
operational preparedness, because at times you have KDF officers expected to even exercise,
yes, go
on certain assignments.
Yes.
So how would you balance the two?
Okay, of course I know that for SDA they have the hours of worship, but I would expect if you are deployed as a security officer, you should be flexible enough so that even within the camp where you are based, you can actually worship. So that you're not saying it is from 8, it is from 5 to 5. You just take a few hours to pray. That's the way I would look at it. But you can't say you leave your camp on Friday evening and come back on Sunday morning. I would not expect that to be reasonable.
Okay.
Yes.
So there is none that would be superior to the other. Individual religious interest.
Yes.
vis-a-vis-
Yeah. But there will be none that is superior to the other. And even there will be times when you are told, like, for this period, you cannot worship because we are at war, for example. So I think it really depends on the job that you are doing. If you look at that case, these were bankers. So I thought that with technology, they should have been, there should have been a flexibility for them to worship and also work.
Okay.
Yes.
And lastly, what are some of the factors a court is expected to consider before ordering reinstatement of an employee?
The primary one is the practicability of that remedy. Of course, the law says that if you've been out for more than 3 years, you cannot be reinstated. That is standard. But over and above that, for example, if you work for a small organization that has like 10 people and you've disagreed with your manager, for the court to send you back, actually they'll be sending you to the gallows, because whoever is looking for you will find you. So even for the employee, it is not always the best remedy. If you are in a large organization like government, government institutions where you can be taken to another station, then that can work. And then, of course, you also consider that position that you are holding, has it been given to somebody else? Because you don't want to enforce the right of an employee who has been terminated and in the process violate the rights of another employee.
Okay. You state that the law provides that you cannot be reinstated after being out of service for 3 years.
Yes.
If that is according to you.
Yes.
So recently, the Supreme Court, in the case of Kamande versus the Judicial Service Commission, reinstated a person who was out of office for a period of 5 years, over a period of 5 years. Where does that place?
Okay. The law gives the option of re-engagement in such a scenario where, you see, reinstatement is that you come back to the exact
I would
position.
have expected. Well, let me finish my question first.
Yes.
When it comes to the place of the law,
Yes.
and what the court has decided, where would you place the decision of the Supreme Court and what the law says?
The way I understood that decision is that the Supreme Court ordered re-engagement. I did not understand it to be reinstatement.
Okay.
Yes.
Thank you.
Yes.
Thank you. Thank you, Chair.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, Your Honor.
It's been a long morning spilling over to afternoon.
Yes.
Yes, I'm looking at your performance results from this POP. You are alone at Nyeri.
Yes.
So there's no comparison.
And I have just reported in October.
Oh, really? Okay. So the only thing we can compare you to is the performance targets.
Yes.
And so I just want to hear from you as a judge of the ELRC.
Yes.
What should be your targets in terms of judgment annually?
In terms of merit productivity,
Yes, merit productivity.
it's just
Merit resolution, sorry, not productivity, but merit resolution.
just of, is it 115, I think?
How many judgments are you supposed to write in a month?
20.
Are you sure about that? That's mine.
Is it 20?
That's mine, Judge. Yours is 10.
Yes, 10.
Yours is 10.
10.
So if we take away 1 month when you're on leave, that should be 110,
Yes.
not 15. Yes. So I'm looking at your performance returns. You seem to be doing okay, especially the previous years. There was a dip in 24, 25. Maybe you can tell us if there was, at least is the time you were transferred then to Nyeri. Is that so?
No. I was transferred to Nyeri in October
October of 25.
or 2025.
Okay. Because what I have here for your judgments No, your merit resolution is 115, so that is fine, because judgments is just the pure judgments, so that is okay. So essentially, Judge, you are doing well. Even the half year, if you are to look at the half year report, I see you already have over 50 judgments for this half year, for the financial year 25-26, so I think you are doing well. So maybe we can discuss something else.
Thank you.
The term judicial craft. What is your understanding of judicial craft, and what are its components?
Judicial crafts are the abilities and skills that a judge or a judicial officer brings to the work that they do. That's the way I understand it.
Yes, that is correct. What are the key components? You can give me 3.
The key components would be the ability to understand the matter before them and to apply the law to the facts. And ability to also apply the Constitution in appropriate cases.
So that's essentially the ability to understand and apply the law and interpret the law.
Yes.
Yes, that's one component. Another one?
The others escape me.
Okay. Maybe you will look at that later. Is it important for the JSC in recruiting judges, like in the exercise we are currently undertaking? Is there a sense or the abilities of a judge in terms of judicial craft? Is it important for JSC to consider that?
Yes, I think it is important to consider that, because that's really what we do on a daily basis. I mean, you get all sorts of cases, and, for example, the ability to apply the law in appropriate cases is really key, for any judge or judicial officer. Yes.
So would you say that a judge, or a candidate for that matter, for judgeship who has not been a judge will not have judicial craft, or will not possess judicial craft, in your view? Is it limited to only people who've worked as judges?
Well, I wouldn't say so, because of course the Constitution recognizes other experiences that people can bring. But I would say that somebody who has gone through the system from the magistracy all the way up obviously has more experience, because they have handled more cases. But that does not necessarily mean that they are better. It just means that they have more experience, and therefore the learning curve will be not as short as somebody who comes from outside. That's what I would say.
Okay. Thank you, and I wish you well, Judge.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
How would your colleagues describe your professional integrity?
I think they would say that I am consistent in terms of my integrity, because I believe that my integrity has been tested over the close to 14 years that I have worked in the judiciary.
Okay. Some stakeholders have commended you on your integrity. However, there are some who hold contrary views, and they have cited some instances where you occasionally demand your drivers to be paid per diems when you have sent them to run your personal errands. And some said that while you are in Mombasa, some staff members perceived you as being discriminatory, and some cited some instances where you clearly stated that you did not want to work with staff from Coast. What do you have to say about that?
Okay, I don't remember demanding my driver to be paid per diem for running errands. my personal errands. So first of all, my driver does not run my personal errands. Now, the Mombasa incident, when I went to Mombasa, I found staff who had worked in that station for very many years. And there were challenges in that station. But I did not say that I did not want to work with staff from the Coast region. I just said it is good practice for the transfer policy to be observed. So that is the only incident that I recall about Mombasa. But I did not say that I did not want to work with people from Coast region.
Okay. No. Fair enough. Now, should the judge be involved in the budgeting process?
Yes, I believe so, because the judge is involved in the core business of the judiciary, and it is in that budgeting process where what is required for the court can be prioritized and put on the table. Yes.
So in the event that the budget for the Court of Appeal is cut by 20%, what innovative non-financial resources would you leverage on to reduce the case backlog without necessarily having the financial or the monetary resources?
I would recommend use of the technology that we have already rolled out, because the judiciary has a very effective ICT facilities that we can use to hear cases. And of course, appeals, you do not need witnesses, so you can hear them from wherever. So I do not think that the reduction of budget should affect disposal of appeals necessarily.
Thank you, Judge. I wish you all the best.
Thank you.
Good afternoon, Judge.
Good afternoon, Commissioner.
Please tell us, how do you handle negative feedback and criticism?
I introspect and ask myself, this criticism, of course, after I have breathed in and out, because there are times when the criticism is not fair, but then I go back and retrospect and ask myself, could I have caused this person to say what they did? And there are times when we have blind spots. I mean, we all have blind spots. So I do a lot of introspection.
Okay. You're in the Employment and Labor Relations Court.
Yes.
What would you say are some of the emerging trends in the management of people in the workplace?
We have challenges of working remotely, for example, in terms of when people are working remotely, how do you control them and how do you manage them? Then there is the challenge of what I would call issues of mental health. They have really begun to manifest themselves, and the stick is no longer working. And therefore, I would say that just soft skills to manage staff who may be struggling. So those are the ones that I say.
Okay, you've mentioned the issue of mental wellness. How do you decompress and ensure that your mental health is well preserved at all times?
I work hard and I play hard.
Expound.
That as I work, once I have worked, put in a day's work or a week's work, I find activities that allow me to debrief. I walk, I exercise. Yeah.
Okay. I'm sure you have a team of the younger generation working under you.
Yes.
What are the practical initiatives you've put in place to ensure that they are motivated and engaged at work?
Okay, what I find, the young generation are very agile in terms of technology. So I've also tried to catch up, because they communicate through technology, and they also have an opinion about things. So I listen more, and I engage them more. And I find actually sometimes they give solutions that are quite useful.
Okay.
Yes.
All right. Thank you, and I wish you well, Judge.
Thank you.
Thank you, CJ.
Good morning again, Judge.
Good morning, Commissioner.
Right now, although already it's afternoon, now, do you sometimes participate in community service other than your rigorous legal responsibilities?
Yes, I do. I am very involved in my church, for example.
Yes.
And I do a lot of activities in terms of supporting churches and supporting ministry.
Yes.
I also assist at the village level in assisting families who may be in difficulty. Yeah, so that's what I would say I do.
Why do you believe community service is important in public institutions?
It is important because it is a way of us giving back to the community, from whom we get the resources that we work with.
Yes, and how do you ensure community service initiatives are inclusive and responsive to local needs? Through
engagement of the community, so that you don't just bombard people with projects. You don't sit in Nairobi and think that this is what the community needs. So you'd have to discuss with them and find out what are their real needs, because there is what we think they need, but they are the real needs that they have.
Okay, thank you. Thank you, CJ.
Thank you. Thank you. Judge, I think we have almost come to the close of this interview. But before that, I would like you to clarify one issue which was raised about the way you conduct proceedings, especially where the parties had entered into consent, agreeing that when undertaking the elections, one position would not be filled. But you overlooked that consent and allowed the elections to go on, despite, there having been a consent by the parties. So what would you say about that complaint?
Yes, I received that complaint, and the facts of that matter are this, my lady. There were 3 cases. One was filed in Nakuru, and it was transferred to me by my colleague in Nakuru. The other one was filed in Nairobi, and it was transferred to me by my colleague in Nairobi. Then the third one, it was presented to one of my colleagues, and if you look at the consent that was drafted by the parties, it actually contained judicial pronouncements. For example, it said, it did not just say we are withdrawing the case and, so the parties went ahead and made judicial pronouncements saying the complainant can run for any office in the union. Now, when I was now presented with a similar case, questioning the capacity of the complainant to run, then I asked myself, okay, there is this consent which was adopted by my colleague, because it is not my colleague who wrote down the consent. It was actually the parties who wrote down, and they made, sorry, they made judicial pronouncements to the extent that they were saying that the complainant is not barred by any law to run for elections. And therefore, I now had another party who brought the same question to me. And I asked myself, as a custodian of justice, what am I going to do with this party who is complaining about the capacity of the complainant to run for office? So what I did, and you know, if you check, that was 2016, we were still running open court. And so I summoned the advocates for the parties. And at that time, the complainant was being represented by the same council as the union. And we had a conversation. So I called the petitioners' council. I summoned the petitioners' council, and I summoned the complainant's council. And the complainant had the same advocate as the union. And this was the eve of the elections. So I asked them, you are officers of the court. There is this question whether a member of parliament can run for union office. It's a substantive issue. So if I do not hear it, what will this other party do? And again, I was thinking that this is a union that has many teachers as members. So the parties that were before me were not the only parties who had an interest in the matter. And counsel for the complainant agreed that, Judge, let us vary the earlier consent so that you can hear this matter on merit, and so that you do not stop the entire elections. Because the other option that I had was to stop the elections on the eve. And I thought that would be very disruptive. And because it was only this one position that had an issue, we agreed that let us delay it so that you can determine this question. So it was not ex parte, it was not suo motu, because counsel for the complainant was in court. And I have provided the handwritten notes that show that counsel for the complainant was actually in court, and he agreed to that. Yes.
I think I'll take that answer, because your court is also inquisitorial. So how do you think we can reduce, because I think it is palpable that there is tension between the various arms of government because of the role of the judiciary in balancing and checking. How do you think we can reduce the tension between the various arms of the government?
I think if each arm does its role according to the Constitution and the law, there should be reduction in tension. For the judiciary, because the judiciary is usually the last port of call, I think we should, as far as possible, allow the other arms of government to do their work and do their processes to the end, because we also know that we can undo what they have done. Because I think the tension comes where we interject in the middle before they finish their processes. For example, if it is a legislative process, you know, I would say that it should, as far as possible, be allowed to proceed. Because at the end of the day, that statute will be subject to scrutiny by the courts.
Thank you. Thank you very much, Judge. I think this brings us to the end of a very robust engagement with you this morning. And before we release you, we always give a candidate the floor to also engage us. So the floor is yours now.
Thank you, my lady. First of all, thank you for the opportunity that I've been given by this commission to appear before you. I just have a comment about the performance appraisal system that we run. We do very well in measurement, but I feel that we could perhaps put a bit more emphasis on the management, the performance management of it. And by this I mean that the supervisors, whether it is heads of court or whether it is presiding judges, could be given a bit of leeway to work with the judicial officers and the judges that they work with, so that issues of performance can be managed at that level. And even at the Chief Justice's level, there ought to be some sort of leeway for the Chief Justice to work with us as judges and correct us. Because, you know, when you are at the workplace, many things can happen. And I would say that some of the things that trouble us could actually be addressed if we put a bit more emphasis on the management aspect of performance. That is my comment.
Yeah, very good comment. That judges should support each other if you're presiding judge.
Yes.
Isn't that the role of the presiding judge when you are in a station? Isn't that the leadership role of the presiding judge or the principal judge or the head of the station?
You know, I would say that we need a formalized way of doing that, because what is the difference then between that support and judicial supervision? Because you see, a judge will say, I am independent. So you cannot even, you have no room to ask me questions. But if we formalize it and we have policy guidance, then we normalize it, and you'll find that, you know, these things that trouble us, some of them will go away. That's my view, Chief Justice.
I agree. Yeah. So we'll be engaging you on that. Yeah, to see how we can help the presiding judges do the work of mentorship and especially on performance. Yeah. Anything else?
No, thank you.
Thank you very much for coming. On behalf of the commissioners, we wish you all the best.
Thank you.
And we'll get in touch with you when we complete the process. Meanwhile, keep up the good work.
Thank you.
Yes, and since you are handling a station, you're managing a group of people, do your best in leadership.
Thank you.
Yes.
Thank you, my lady.
And do a selfie.